on it. I don't know if I'm an expert, but we see a lot of it. I don't believe that we have any ringers in the Constitution that hobble our judicial system. The 1963 Constitution, I would tell you, is, I think, a pretty well done instrument. There are sometimes people who have complaints about it because something either is or isn't in the Constitution. State constitutions tend to be much more lengthy than the federal one. But leaving that aside, and whether something should be covered that isn't or vice versa, our state constitution is basically a very governor-friendly constitution. It gives the governor a lot of power. We've just lived through an era in the Engler years where for 12 years you had a very strong governor who used the powers of the governor very aggressively. Our court, and this for the most part was long before I was on it, but our court indicated that we thought that was really well within his constitutional power to do so. So the sophistication and development of our Constitution from the time it was adopted in the mid-1960s has really continued apace, and there's a good body of law on what the Constitution means and how the legislature should understand it that is sometimes taken for granted. I think if you're serving in the legislature, everybody says, oh, he can't do that or he can't do that, but every one of those was a great war. and as I say, ours, it has eventuated, is a fairly strong gubernatorial system, which is to contrast it with the 1908 Constitution, which was more legislatively deferential and local government deferential system. But the feeling was in the 63 Constitution that we'd gone astray and that it was hard to govern a state without sufficient centralized power. So that's what we have, and if you want that kind of government, I happen to think it works pretty well, but not all would agree. But if you want that kind of government, this is a pretty good document that we have. It has worked pretty well.
We also have both the citizen initiative and the referendum, and you alluded to already once a recent decision where the court upheld a ballot measure. Michigan seems to have more and more questions on the ballot. There's several being
Actually,
circulated.
I think we have less than most places.
Really?
I was talking to a guy the other day, the editor of the Detroit News, who was telling me that he had just come from California, where he was editor of a paper out there, and he was saying California now is effectively governed by initiative. The legislature is so gridlocked that if you don't want to get anything done, you put something on the ballot. So they'll have, I may be overstating it here, but they might have as many as 100 things, 100 propositions on a ballot. I'm not sure if that number is right, but in any event, it's a big number. Similarly, the Dakotas, they were big progressives at the turn of the 20th century, and this was a progressive movement, was to the initiatives and referendums, which was to get it away from the sullied legislature and get it out to the people where they could vote on it without the special interests moving them around and so on. So Michigan bought into that, but not half as extensively as places like Wisconsin or Minnesota or the Dakotas. But we did get in 1911, I think it was, we adopted referendum and initiative. But even on these things where the people are able to vote on an enactment of the legislature, it's a very interesting provision because it says they can't vote on it if the enactment carries an appropriation. The fear, I think, was that the people would vote to not have money be appropriated, and that state institutions it'd be pretty hard to defend in sort of a broad popular way appropriations. And so the drafters in a constitutional amendment, I think in 1912 or 13, said, yeah, we'll have this power, this initiative referendum power, but we're not going to allow them to vote on certain kinds of things. So Michigan has a much more narrow power.
An appropriation is not allowed in an initiative.
Right. You cannot get that on there.
Is it common then, once a measure passes, for it to be challenged? I suppose if it's controversial, I mean,
well, I think it tends to happen. I think it tends to happen on the hot button issues. So, for example, in the mid '80s, the Democrats and the Republicans in the legislature effected compromises regarding workers' compensation. The left got something, the right got something. They both had points of happiness and unhappiness. And over the years, these sort of pressure points in the system tend to result in litigation. And the litigation comes through the courts, and eventually somebody sitting in one of the seats like mine makes a call on what the legislature said and what it meant. So there are a lot of efforts, I believe, in this state and others to deconstruct legislation that you didn't agree with by the process of litigation.
What are some other examples of courts that have legislated where maybe they shouldn't have? You gave the California example recently.
Well, I mean, in the same field, there's the Massachusetts Supreme Court with the famous Goodrich case where they said the very same thing, that is same-sex marriage. That one was really an aggressive court. They said that the 1780 Constitution, drafted primarily by John Adams, a very stoutly conservative man who became our second president of the United States, that this 1780 Constitution had thought about homosexuality, which I found on its face sort of strange. I mean, I bet you John Adams, it's hard to imagine John Adams thinking about homosexuality very much and thinking that he'd written it into their Constitution. But in any event, that's what the Massachusetts Supreme Court said. In a broader sense, the occasions of sort of excessive power being exercised by courts are unfortunately not hard to recall. I mean, probably the most famous one in the country is the Dred Scott case in 1857, where the United States Supreme Court said that the Constitution effectively constitutionalized slavery in the sense that slaves could be brought into the territories and that no state or federal government legislation could stop that. Everybody pretty much agrees now that was a lousy decision, but that was
the law of the land for a while.
That was the law of the land. And a lot of American historians think that that piece of judicial work brought us the Civil War, because effectively the institutions of compromise in our government, the legislative bodies, were put out of business. I mean, if it's writ hard in the Constitution.
So there are consequences to a court going too far.
Yeah, I mean, that's really the most draconian kind of consequence, that the society falls apart. Most often won't happen that way. And fortunately that is. But that is really the downside on courts. See, the theory is developed in the 20th century that, you know, judges are smart and well-educated and from elite backgrounds and so on, and they just do better at this than the common man would. That is, that they would do better at forming policy. It is not the case. I mean, I think Justice Scalia on the Supreme Court says this beautifully when he says that nothing I took at the Harvard Law School gave me any insight into when life begins. There's a real point there. I mean, the determination of when life begins is really not known in the sense you can know a mathematical sum. It really is one of those kinds of questions that normally we leave to the legislature to make a call on. And in the case of Roe versus Wade, of course, the court took to itself this power, and it has produced tension and friction in the system for the 30 or 40 years subsequently.
My guest is Clifford W. Taylor, Chief Justice of the Michigan Supreme Court. And Justice Taylor, we only have another minute left, but I wonder if in closing you might say something about the ability of visitors to come to the Supreme Court. I had a chance to see your nice little historical gallery. It is open to the public during certain hours?
Yes, it is. We're open, of course, during the weekdays. We have on the first floor of the building, the building, I should tell you, is sort of the bookend of the state capitol. It's down on Martin Luther King, down the mall from the Capitol, going west from the Capitol. It's a beautiful, beautiful building. It's about 5, 6 years old now. The first floor of the building has a learning center. It's one of the most attractive draws for school kids, I understand. And this display in there is interactive, and their computers and whatnot, and the hope is that this will make children be familiar and understand their legal system, and that they will come to appreciate it and value it, as it is really the crown of civic life in the United States to have a judicial system of the sort that we do.
Thank you very much for coming on my program, and hopefully the citizens of Kalamazoo, when they come to the state capitol, they'll make a visit to the Supreme Court building as well. Thank you, Justice Taylor.
Thank you very much for having me, Senator.
Thanks for watching my program. This has been Current Events with State Senator Tom George.